Okay. You wrote a book. Okay, this is Stephen G. Erickson. It's December 4th, 2009. I'm here with Barbara Johnson. She's the former candidate for Massachusetts governor. She was also a lawyer in Massachusetts, and she wrote a book called Behind the Black Robes, Failed Justice. Go ahead, Barbara.
Plural, R-O-B-S.
Okay.
Yeah.
How long did that take you to write?
Oh, I started last September while I was still in Andover. But at that time, I was just fighting the bar on, in the federal court, a little different. The state court had asked the federal court to impose the same discipline. I hadn't done anything in the federal court that required discipline, so I had to write what it was all about, and I did that and fingers rubber stamped, and it was just a formality. It's part of Federal Rule 83.6, I think, and where they have this it's like having cooperation between the state and the feds. And then I appealed the rubber stamping of it to the First Circuit Court of Appeals, and they just rubber stamped. But still, I wanted to make a record. In case they said something, maybe I would have brought it to the Supreme Court of the U.S. Under 1%, the chance of getting cert would be under 1%. So it had to be something good if I bothered use my time to try to go to the Supreme Court again. And they just represent, neither the district court nor the circuit court of appeals wrote anything. They just literally rubber stamped it. They said this is what they want and this is what they get. They quoted the rules and they said this is allowed. I mean, no facts, no law, no anything. I mean, they were really whores of the court. They really, truly were. And I wrote that in my book. The book is not about me, just one chapter. And here and there I might have mentioned a few things. But I did write that they were whores of the court, because that's all that they are. And I didn't bother bringing it to the Supreme Court. I thought I'd get nowhere. Although I did hear that one Supreme Court justice, who will stay nameless for the time being, actually read a brief of mine on one of my prior petitions to cert. And he liked it. And my friend, one of my friends, not from Massachusetts, who knows this particular Supreme Court justice personally, had given me my brief.
Are you willing to name that Supreme Court justice?
Not yet, because I have to protect you in the meantime. And the Supreme Court justice, I'll tell you this though, it makes it real. When he went over to his house, the Supreme Court justice's wife did open the door, whatever, and he said, why he was there, and he said, the justice was put by jellyfish today. Did nothing in the bedroom all night. And I guess he was reading my petition up there. And I never knew exactly what the justice said, except my friend who did have a bar, and still does, he is a bar member of the Supreme Court bar, wrote me and said, if you get cert, I want to sit second seat. So which meant he wouldn't have wanted to sit with me if I was a fool or if the brief was frivolous. He wanted to be part of the action, and he was willing to, come out of the closet on that. But we did not get cert. I did not get cert. I'm just assuming that the justice that he contacted was in the minority, not the majority, at the conference where they decide whether or not to take the case. So, in fact, I received an email from him last week. He wants to give a copy of my book to that justice, and he said, I want it autographed. So now we
And we're talking about Washington, D.C., correct?
Right, I'm talking Washington, D.C. So it'll be somewhat interesting if this particular judge actually does read it or comment on it. So we have a foot in the door, a toe in the door, I should say, rather than a whole foot. But it was it's been interesting. I didn't bother to go to the Supreme Court on this because there was nothing for them to decide. There were plenty for them to decide, but they weren't going to give me cert on it. I don't. It was just Massachusetts wanted to end Massachusetts. It was clear as a bell. And other things, other reasons that I know that I can't really say. Well, I can say them. Just complicate things, and I want this to be. I don't think this is the show to say it all on, although it would be an exclusive if you had the story. It's interesting. All I know is that my feeling is I got, a little more than gut feeling. I do know that the Massachusetts court wanted me out of Massachusetts. And I was lucky I got out a month before that book got released. As I say, I started writing it in September, which was your original question, how long does it take me? In between arguing with the Federal District Court in Boston, arguing with the First Circuit Court of Appeals, arguing with my son over a personal family matter, which is important. And in between, I wrote the book. And I finally sent it in to the publisher, finished in May, the final copy. And I left in July, and it was published on Amazon in August. I think Amazon says August 20th, but I first learned about it August 24th. And so almost a year from beginning to end, but I certainly didn't write it. It didn't take me a year to write. Basically, a day or two on each chapter. Some of the longer ones, some of the more complicated chapters that had more legal stuff in it, took me a little longer because my research was greater. But I didn't want to bore the reader with, reading legal citations because it just interrupts the flow of thought, and it doesn't make interesting reading. So I put all of the citations and a lot of the legal research and some of the dirt, because I didn't find some scandal on some of the judges. But some of it I also put in endnotes, not footnotes. I didn't want to clutter the page. I wanted a 3-page that makes easy reading. And if they wanted to know more, they wanted to know the research, and they wanted to know the sites. For instance, if they had an ongoing case that they would need sites for. Those are all in the endnotes. And so I have 300, I think someone actually looked at it. I didn't look at it. 360 pages of text, and I think 105 pages of endnotes separate at the end of the book.
Yeah, I looked on Amazon.com, and there's, I guess, 5 comments so far. 4 of them are 5-star, which is hard to get, so it must be a pretty decent book. You wrote it to abolish judicial immunity, and there should be some sort of civilian oversight of the courts. Is that something that you are looking to advocate for?
Yeah, I want court reform and the abolishment of judicial immunity. I think it is the fact that we have, that the judges have given themselves immunity is the problem. If we can get a few judges actually off the bench because of their conduct, all the other immunities, the quasi-judicial immunity, which simply is immunity just like a judge, that's what it means, which they give to family service officers, to guardian ad litem, to psychologists, to people they call guardians ad litem. They called different names in different states. But the people who the court appoints, receivers, then can go into court. They have a business, and suddenly the court puts a receiver on the job. Then you have, the receiver has immunity. The receiver then has his lawyer. Then the accountant has immunity. The accountant has his lawyer. I got into one case where there was a receiver, two lawyers, and two accountants, and two more attorneys. It was crazy. And then the guy, all of them were paid out of his business. It was I wrote about it in the book. In the chapter, I forget the name of the chapter, but the comment of each chapter has a little explanation, right? A sentence right after it. And I called that From Riches to Rags. In 6 weeks, a business that they did half a million, I think it was, I don't remember, so long ago, $500,000 a month. Okay, just went from riches to rags in 6 weeks. They cleaned him out. They just cleaned him out. And
So the court system is harming businesses, small businesses. Seems like they're breaking up families. It also seems like it's a monarchy system where, like it's they have robes, titles,
They have robes. I didn't catch your second word.
Monarchy, like as in,
Monarchy,
yeah.
it is. They made themselves kings. Exactly. But it was done in 1880 in the U.S. Supreme Court, and Justice Fields, I forget his first name, is the one who wrote the opinion. Three years prior to that, there had been another case from Massachusetts where Randall versus Bingham or Brigham, I forget. I knew someone by the name of Bingham, and I keep on mistaking it with Brigham, which is the ice cream store. But Randall v. Brigham, I think. And that was someone was disciplined by the bar, and he appealed that. And they said, okay, because judges have to remain independent, we will allow them to be independent, but if they're malicious or they're corrupt, then we'll get rid of them. 2 years later, Justice Fields came along in a case called Bradley v. Fisher, and said, no, it doesn't matter if they're malicious or corrupt. They have to retain their independence. I read that and said, oh my God, what could be malicious and corrupt again? And that is the law as it stands now. Not written law, it's common law. Not in the statute, and it's not in the Constitution. The Massachusetts Constitution, which was written about 14 years prior to the U.S. Constitution, and the U.S. Constitution both have provisions that for bad conduct the judges can be removed. And so when I did my appeal of a case where I sued some judges, I asked, I knew they had immunity, but I figured I would try to bring it all the way up to get it moved on. And I asked very simple questions. What constitutes good behavior on part of the judge, and what constitutes bad behavior on part of the judge? They refused me search, but it was certainly relevant, and it certainly had national importance. But they didn't want to tackle that problem. And then they say the statute basically gives them two exceptions to the immunity rule. One is if they act criminally. But you cannot get a court to declare that the conduct of the judge was criminal. So that's one exception, which is really nothing but a smokescreen. And the other one is if there is an absence of jurisdiction. Just recently, within the last few years, I don't remember the case name, but there was a new case, a very recent case, where they narrowed what jurisdiction is. And so that an absence or excess of jurisdiction out of my mind because keeping it in my mind just aggravated me too much. And they just narrowed it so that was the other exception. If they're absent jurisdiction or actually in excess of their jurisdiction. And now, on the current case law, again case law, not statutory and not constitutional, case law, under case law, that jurisdiction, that exception has even been further narrowed. So there's, the two judges recently that have been sacked are the ones from Pennsylvania who took all those bribes in those juvenile cases.
They put kids in jail. They took money to put kids in jail, but those are just a few that were caught. So there's bad behavior and criminal behavior of judges, and most of them don't get punished.
Exactly. I mean, the ones in Pennsylvania, the proof they had was so clear-cut they couldn't say it wasn't criminal because they clearly got kickbacks and everything else. So, but beyond something that's sexy, like one judge masturbating in the court, how people were there, or one actually drinking booze at the bench, people knew it, or one, nothing's really sexy or scandalous, you're not going to get them out. And of course, most of it is motivated by money, by greed and by money. They get the bonuses from the federal court, and we don't know. I mean, in Massachusetts, I always said we needed some investigative reporter to follow certain judges down to the tape of this in the summer or long weekends, and then look up that address and find out who really owns it. You will find that it's a nominee trust, which we have in Massachusetts, and you don't have to put who the beneficiary of the trust is.
So judges are getting bribed.
Trust, but it's the judge and his wife and whoever else, or his mistress, who really is enjoying the benefits of that, you see. So it's not cold cash that passes hands. It's things that are sneaking that pass hands, And people are mistaken that they're going to find cold cash. They're not. That's where the Pennsylvania judges went wrong. I mean, there was too much evidence because they passed cash.
So most judges don't get in trouble when they get bribed if they have a way of sneaking it in. And it's also retaliation when a lawyer or somebody else goes after a judge. What happens to that person?
Well, I was made a martyr to that. That's what the whole thing was. In their petition for discipline against me, I think they said that clients had complained. There were no clients who complained. Remember, in my case, there were no witnesses. They never put any witnesses on. If a client had complained, you can be sure that some angry client would get up there on a witness stand, wouldn't they? But that never happened because there weren't any. In fact, I had clients who went the opposite way, who called them, gave the bar help, and he was doing this because one were pleased, and there was no complaints. Then they said that I had put up a psychological, they actually were clear, they said a report, they didn't make it clear, but it was a psychiatrist's psychological report of someone on my website. Well, I said, where is the report? All my files uploaded to my website, falseallegations.toro.com, were uniquely named, unlike some websites where they have the same URL for all the files on their website. Mine are all uniquely named. All they had to do was look up in that little area, the field, where you put the name of the URL, and tell me which file was it. They couldn't do that because it never existed. They said that I commingled funds. I said, what funds? And they never could put that. I said, well, was it $1 or was it $1 million? The objections to the day. They couldn't say that because it never happened. In fact, ironically, well, not ironically, well, I said, what justice? I don't see any justice anything to do with it. Oh, hold on 1 second. Hello, Diablo. It's a very, it's supermercato. Yeah, shoot back. Let me back. Sit down. Sit down. It's a tough day. Call me down. Okay, call me down there. Yeah.
Okay, I stopped it and I started it again.
Yeah, you can take that up. And it's interesting, they said that my criticism of judges, that happens to be true. It didn't make favor of justice, but I certainly did criticize judges. Go on my website, you'll find dozens of names of judges that I criticized, but they never did name one. It's very interesting.
So they put the They put you in jail for how long to punish you for criticizing judges?
No, that's not why I went to jail. Well, I went twice. Once in 1998, where I found a contempt of a non-existent order. Oh, I'm sure there was feedback on that one. That was crazy. And so I went, it took a day to get out because one of my sons went to court to find out what the ransom was, you know. I said, there's no order. They're not supposed to pay any money. On any amount, it doesn't name a person to whom I'm supposed to pay it, etc., etc. I said, there was no such order. So just on the third day, in Concord, hold on, there's talk everywhere. Hey, hello. Hi, I'm on the being interviewed now. Can you call back in a while? Perfect.
Okay. Tell me when you're ready again.
Yeah, I'm ready again. That was a call from Australia.
Okay, you calls from all over the world, huh?
From all over the world. Well, that's an attorney whose car was firebombed in Australia for criticizing judges. So he might come to Costa Rica.
All right. So when the justice system does you wrong, or you complain about the justice system from the inside, so Costa Rica is the place to go, huh?
I guess so. He figures it's far enough from Australia, except he needs $1,200 to get in here. He had been very prestigious and very well off in Australia, but with the court, they managed to sell his properties. They didn't even have anything to say. We're talking multi-million-dollar properties. So he really had a problem. And he wants to come and join me. And he sent me the outline of a book that he wants to do. And we're in the point, should he do a fiction or nonfiction? He's brilliant. He's handsome. His stuff is really something else. He's charming. I think he was in his early 40s somewhere, young man still. And just was really a corporate and governmental, international government lawyer. He really didn't have anything to do with family court. But his personal life got involved in family court. And he said it was just crazy. His experiences for the last few years has been absolutely wild. But he said they actually have hitmen down there, and that's why his car was firebombed. So he is quite concerned about his personal safety.
Okay, we'll maybe stay in the United States, talk about that. But organized crime, it's official. The judges, the police, and the government seem like they're organized crime the way they act. If they send thugs out, if they do hits, etc. Do you find that to be true in our country?
I don't know many hits in the U.S. He was talking Australia. I don't know many hits. I mean, I would get hit, if that were their M.O., but I never felt any danger that way.
Okay, if they didn't actually send somebody out to kill you, they can put you in jail, But what type of sneaky things do they do in the system that they do to you or do to other people?
Okay, well, okay, the first time in jail was sort of separate. The second time was actually when I was arguing the disbarment and the contempt. Now, I found disbarred and found the contempt at the same time. The contempt was I was to write my withdrawal from my cases. Now, I had already narrowed the cases down because I knew that that I'd be disbarred in the day, and I wasn't sure when. So I purposely had, finished up 50 cases after a certain period of time. And they wanted, when they told me to write all the lawyers and all the courts and all of this, I said, hell, this would take me a long time. And plus, I said, it's my clients who would suffer. If they didn't do anything to move their lawyers off their cases, and the cases were fairly complicated, the ones that I took. So I said, they won't have anyone to replace me because no one else is going to dare do it. Plus, their cases were too far along to suddenly have a new attorney on them explain the whole thing. And they had warned me not to explain anything because it would be unauthorized practice of law. So I said, no. Your punishment, man, disbar me. I don't care. I'm old. I'm not looking for more practice. That's no problem to me. What is a problem, however, is that you're punishing my clients because they had me as their lawyer. And you're interfering with their rights of due process and equal protection. Therefore, I am not going to write their lawyers. Plus, they already know about my problems at the bar. I put everything on my website so everybody has been able to follow it daily. I said, but I don't want to resign from the case. Let me just start, let me finish up the 50 cases I have. And one of them was for huge money, and we had won all kinds of things in that case. And he could have retired, I could have retired, gone around the world a few times. I mean, it was that good a case. And they refused. And then they wanted me to write these letters, and I refused because I said, no, my obligation is to the client. I took them on saying I would represent them, and I have that first obligation is to them, and then to the court. And plus, I said, what you're doing is really punishment of the client. And that's unfair. Fundamental fairness is the cornerstone of due process, and you're not being fundamentally fair to my clients. And so when I would not send those notices out to the lawyers and to the courts, that's when they put me in jail for contempt of a court order. Okay? I was in there 5 days, and under the help of 5 human angels, I was probably still be in there. Because I could not, I didn't have any of the addresses in jail. I was given a steel slab to sleep on. There was no table, no pen, no pencil, no paper. And there was no way to access. And lawyers change offices or companies for law firms very quickly. So I was unable, I didn't know all their addresses. I had the boilerplate on my computer. And there was just no way. I just kept the docket. Remember that awful boilerplate? I don't type that each time. I would just copy the caption in. So, I wrote the docket number the first time, but I probably used it 100 times later, but never had to type it again. So I didn't memorize those numbers. That's what the computer's for, to do all that crazy memory stuff. So, that was essentially it. I could not have complied with that order from jail. So I said this was criminal contempt, not civil contempt. Civil contempt is when you hold the key to the cell door. Someone tells you to pay $100. Pay the $100, that's out of jail, never recently worked there, and he had heard of me, suddenly came to me, and I couldn't, he had to send all these notices, certified, return receipts, and copies to everyone else. It was very complicated. And he put it all on the sheriff's tab. Sheriff of Suffolk County paid for all of that. It was funny. He did it, took it home with him, dropped some stuff off at the my house and went there also. So there really were 5 human angels at least who helped me get out of the jail. But it took them 5 days to do it.
It sounds like the kings of the court threw you in the dungeon. I've talked with people.
They put me into a hospital room so that I could not converse with anyone. I would be essentially in, what do you call it, in solitaire.
Was it they mentally committed you because you criticized the court?
No, they just didn't want, if I was in the criminal population, as I was the first time for a few hours till they got wind of it, all the criminals were asking for legal advice. They didn't want anyone sharing any legal advice to anyone. And so the second time, they never called it criminal contempt. They always called it civil contempt. But neither time was it civil.
Okay. I've been talking with people from the Connecticut courts on the inside. They mentioned that there's a government workers union that basically they go after lawyers, they go after people on the inside. Using the union, they hire private investigators to go after them and intimidate their friends, gather information, and it's basically that's the inner spider web of corrupt courts in Connecticut. Is there such a thing in Mass where the government union goes all the way through, where it's town hall workers, it's police that are part of the union?
I'm sorry, I have no personal knowledge of that. They might, but I don't have any personal knowledge of that.
All right. So, what is the inner spider web of the Mass courts or of other state courts that how they can just go after people and just take apart their lives when you complain and you want reform in the courts and reform in, say, police too?
Well, there are 50 states, and everything, the dynamics in each state are probably different. There's no question that all of the people in the judicial branches of each of these states has power, and they use that power. And whatever is the custom or practice in their community, they will use. I hear it. I mean, you see it in California with Richard Mine, Jack Thompson down in Florida. You talk with Kennedy, and I think she was from Virginia. There was a guy in Pennsylvania. I mean, there are dozens of attorneys who've been disbarred because they disagreed with the court. And all of the ways in which they have done it are different. You have Isidora Rodriguez from Virginia. He was a normal litigator, but then his wife took his kid back to Colombia, and they were afraid to go to Colombia because of the drug cartel, which is why he left Colombia to begin with. So he's fearful for his son's life. Fortunately, his son now has grown and in college nearby where Isadora can see him. But he had one hell of a fight in Virginia and in the federal courts as well, and they disbarred him. My understanding is they've actually disbarred him, and that's the latest on it. And that man just all of his fight was for his own son. Because he couldn't go see him in Colombia, because he was afraid of his own life in Colombia. So I think that's totally wrong. No justification. His argument was completely like that. You had no right to allow her to go to Colombia and so forth and so on.
The real power in the states and in the country, it seems more and more, it's in the power of judges. If a governor or other official does something that a judge doesn't like, it seems like the official ends up like in jail. Former Connecticut Governor John G. Rowland, he had a conspiracy where, with the Department of Children and Families, Christine Regagula, I guess, was his mistress, and they had a pact where they would, with organized crime, that they would build Kitty Mac's prisons for children. They were both getting bribes, and then the mob the organized crime would run the facilities, build them, and supply them, and they wanted to go national with this. And I guess what happened is John Rowland, the former governor of Connecticut, stepped on judges' toes, and that's why he went to prison, not for taking bribes, not for breaking the law, but for going against the wishes of the judges, the real power. What's your opinion on that?
Well, right, judges have power because there's no oversight. There's no oversight. One judge, with whom I disagree vehemently, turned out to be the man who was doing the oversight of the committee in the federal court that was going to grasp what federal judges would be liable for when they could receive a good gosh, a sanction of kind for whatever they did that was wrong. And this guy, he was going to cover for their asses, and he did. And so he was just one of them. There was nothing. In one case I had in front of him, the policeman actually admitted on the stand that the signature on the complaint for criminal complaint was not his, although it looked like his when you read it. But it was not his. It was forged. He admitted that on the stand. The judge did nothing. Now, the criminal case had long been done away with. We had won that. This was a malicious prosecution case. But it wouldn't. The guy certainly perjured himself on the stand when he did that. But wouldn't you think that the judge would have done something against the prosecutor and the police department for filing a fraudulent complaint and prosecuting this man from under it? Some of the stuff is unbelievable that I could say. I wrote one book, but there's enough there for several books. I just don't know that I have the heart to do it. Maybe I'm doing some fiction, make it easier to read, put it part of the story,
If you have real names and real events, then it's real, and people can get upset and want to do something about it. As far as the RICO statute, going after the court system where, it's like racketeering. They can take money from people, they can take your freedom. When they're breaking the law, what do you think of using federal racketeering statutes, RICO?
Well, I'm sure that some people have done it and have gotten nowhere. You have to show two predicate acts. You have to, show something where they've gone over the electric wires in some way, nails, telephones. There's a lot. Truly complicated. They can twist anything they want. I got to some point where when I look at a case, I read the holding, and I read the headnotes, which sometimes are wrong. Westlaw does a good job. It's not entirely proper. But I'll read that portion of the law. I want to see what the court wants the law to be. Remember, it's all predetermined. So you want to see what they're going to hold. There are times when I don't even bother reading facts because they'll leave out the most important facts. I had a case like that way back when I first began. It was a open and shut case. And open and shut case. And I do that. And can we stop just for a minute because I have someone I have to talk to for a minute?
Sure.
Okay, good. Hey, Isabel, I just wanted to say thank you. I
Okay, okay, you're back.
On my shopping for me, she's an angel.
Okay.
She's wonderful. You're just fantastic. I haven't met a nasty one yet.
Let me ask you something. If there was a people's grand jury system, let's say if there's people that were somehow independently found that they don't have political affiliations, they're not lawyers, if they were part of a grand jury system at the courts, I think people should be able to complain to a grand jury if they find that, there's merit to what the person says, to order an independent investigation. I think we'd be better off without judges at all, and if we had a grand jury system, and if we had a supreme grand jury rather than these justices and judges that wear robes like they're kings and, members of a monarchy. I'm kidding to say.
You would need to, if you're going to have a trial and you're going to have motions, and they have to be decided on the basis of the law, you need someone who has some education into the law. There are lots of pro se. Some people are brilliant. You can do their own work pro se. But others don't know how to read a sentence or write a sentence. And they get creamed. I mean, they're squashed. It's like an anthill. And they're just subject to a lot of things. So you really can, if you're going to be deciding issues, if you're going to be deciding them based on real law, then you really need someone who is familiar with the law. So I disagree. I do understand the idea of a grand jury, something that I guess jail for judges is thinking of, and they tried to do it in South Dakota. And it's a shame they lost. It would have been nice to have that kind of grand jury. Right now, grand juries are something in which prosecutors, all they need is a bologna sandwich and they will get what they want. But a person can testify in a grand jury, but the person's lawyer is not allowed. They can ask, they can write a letter. You see that in Edley Bailey's book. I remember reading that, years ago, decades ago. So you can request to be present, but I've not yet been invited or allowed to attend grand jury. And they lie, the prosecutors lie. Nightfall was not, from the Duke case, he was not the only prosecutor who has used underhand methods. Believe me, that is the MO, and they are taught how to do that. And that is how they operate. Someone should read Judge Malloy's book. I forget his first name. He was the defending judge on Miranda versus Arizona, or Arizona versus Miranda. He's dead now. He died recently. He was 90-odd years old. He was lucid, though, when he wrote that book. Molloy. I don't have a copy of it here to check because I gave it away to a friend who I knew would be interested in it. But it's on Amazon. You can get it. Molloy. His book, too, is worthwhile reading. Some of it's a little unusual, sort of took me by surprise, but it's worthwhile reading. The more you know, the more you have to fight with. Part of your question, is it worthwhile to have a private grand jury? Yes. Is it worthwhile to have a supreme one with people who are not judges who sit on cases? I'm a little doubtful of that. It needs some education.
All right. In Connecticut, the Arthur L. Spada, he was a judge in Connecticut, and then he became the head of the state police, the commissioner of the state police in Connecticut. And I was told that he was also the head of a one-member grand jury system. So if you had complaints about the head of the state police, you complained to him about him. So when I complained about the commissioner, Arthur L. Spada, to the governor's office, the woman there told me that if she forwards the 10-page fax complaint, it's going to go to Arthur Spada about Arthur Spada. And she said, if I fax this over, you'll be arrested and go to jail. So do you want to complain about the commissioner? How fair is that?
We have to repeat it. My friend came in. My baby that came in at the time. I'm sorry. You'll have to edit. Could you repeat your question about Stoddard?
Okay, it's Arthur L. Spada. He was the commissioner of the Connecticut State Police. S-P-A-D-A.
Yeah, go ahead.
All right, he was a judge, and then he became the commissioner for the state police in Connecticut. Well,
What, Connecticut?
the commissioner of the state police, the head of the state police,
State police, okay.
and a grand jury, I guess there was a one-member grand jury, and he was on it. So if you wanted to complain about Spada, you'd have to complain to him about him. So when I complained to the governor's office in Connecticut, they told me that they would fax the 10-page complaint about Spada over to Spada, and I was told that I would be arrested and go to jail if I wanted to make a complaint against the commissioner.
Amazing.
Isn't that amazing?
I've never heard of a one-person grand jury.
I haven't either, but I was told that he was the one that decided who got arrested and if there's corruption or any problems with the system, a former judge that's the head of the police is the one that decides what's going on. So it sounds like the system is completely rigged, at least in that state, if not all of them.
Oh, yeah, I mean, it really is. When I had the personal case with my son, against my son, I never thought it would ever happen because we've been close. It's a long story. At any rate, family cases are often worse than other kinds of cases, just between family members. At any rate, the case had nothing. It was over property, okay?
Yes.
I had given him $300,000 over the years. I set up a trust and made him trustee. And in addition to I had sold my house. I'm telling the story now. Okay, first time it's publicly heard. It's an exclusive now. My son had a house and he was over-leveraged on it. Within 6 weeks of him buying it, this was in '87, and I had given him the down payment of $30,000 for the down payment at the time. This was 2 decades, a little over 2 decades ago. So that was a lot of money. And right after he bought the house in '87, about 6 weeks after, we had what is similar to what has happened in today's market, where the banks were crashing, the real estate tanked, and suddenly he would have had to pay. He sold the house. He would have had to pay $40,000 to $50,000 to the bank in addition to whatever he got on the open market. And clearly he didn't want to lose the $40,000 to $50,000 or have to pay another $40,000 to $50,000 to get out. So he lived there for 2 years. But the economy was very bad in Massachusetts. So he went out to California with his new wife, and he had a fantastic job there. He was always very well paid. My son was very well educated and very well paid. And he went out there. When he came, he was still out there, and I had sold the family house in Massachusetts, which was a nice house. And I was looking for something to do, and I said, he asked me, Mom, what are you going to do now? Where are you going to live? And I said, well, I'm looking at some condos. I said, I'm not interested in maintaining gardens anymore. I've maintained enough of them over the years. I said, from the condo of the balcony of the condo in Johnstown Navy Yard, I saw a robin named tugboat. And I think I was told, remodeled that totally. I'm trying to get him to see it, but he has friends in there, and they don't want to show it to anyone because they don't want to lose their digs. So I said, he said, what are you going to do with the tugboat? I said, I'm going to go down, I'm going to find myself a young Greek captain with completely brown eyes, go down to the Chesapeake, and lose 600 calories of coupling. Mom, before you do something so cockamamie, why don't you live in my house? I said, I don't want to live in another house. I'm living in that house. anyway, basically his tenant was leaving, and he wanted me to live there. I said, oh, he said, I'll charge you the same rent that I charged the tenant. I said, fine. I set up a trust. I said, well, see whether I want to do it, but I'll set up the trust. I don't want any trouble with my daughter-in-law, whom I hated from day one. I knew her before. They'd gone to school together. And I knew where the danger points were, and I figured that would be the end of the relationship if he married her. And he did, and that was the end of the relationship. Not right away, but it's not worth it. It's just something. I call her the witch now, the evil witch. At any rate, and he's too well off. He can't really fight against her because she'd cream it, you know. And, oh well. At any rate, so I said, okay. But a few years later, he came back to Massachusetts, and they told him he could not go back into the house that I was in, that I rented from them on a temporary basis, because it was too small, and they had become very accustomed to socialist living out in California, Menlo Park, next door to Palo Alto, which is a very affluent community. And he had that money. I mean, we're talking years ago. He was probably making $150,000 then. So that was a lot of money back then. You could sort of double it for now. I don't know what it would be equivalent to now, but he was not a poor boy. So they bought a home in Hamilton, Massachusetts. Another very, very affluent community in Essex County in Massachusetts, north of Boston. And when he did that, he still didn't want to pay off the house because the market hadn't quite come back yet, 97. The market had not come back, so the house was still over-leveraged. So I gave him, he put his money into the trust, $30,000, $40,000 every year. So I gave him another $150,000. I said, pay off the damn mortgage. Get rid of it. I didn't know that. And I think it's good because I was ready to retire. I was already on Social Security. I'm 75 now. At that time I was 65 or thereabouts. I was a little older actually. I have to figure it out date-wise, whatever. But I was still already a senior. And I said, just pay off the mortgage. And I figured I could live there on my Social Security, which is very small. It's really just a stipend. And which is because my first job, for instance, I was paid $19 in debt, so you can imagine how much Social Security went in for me at that time. And other women of the same age are suffering from the same problem. Very low, literally stipends from Social Security. You can't really live off of it anywhere in the States. So, so we said, okay, look, I have been covering all the expenses here in the house. Everything that breaks down, because the mechanicals in that house are really old and really needing replacement. I put circuit breakers. I said, my God, Mark, how did you live here? I'm surprised that the house didn't burn up with the wiring in here. You know, it's awful. It's got to be replaced. That's put circuit breakers in there. I put circuit breakers and sprinklers because I didn't have any time to stand there with the hose. I was always in court. And so forth. I did all the repairs. And after I gave the house, we made an agreement that I had a license to stay in the house. So I kept on giving him money, and I actually did a chart later on. I found out that I paid 14 years rent in advance. So it would have kept me until I was the age of 90-something. At any rate, one day, in 05, September, I received a handwritten letter from my daughter-in-law, evicting me, saying I said, what the hell is this? I had given him, I didn't know, I hadn't added the money I had given him. Since then, I have added the money because I had all my canceled checks, copies of wire transfers, because you never know when someone's going to come after you, so you really want to have your proof, and I saved all the papers in the file, of course. And it turned out that I had given him $300,000, the house of reason to play. I gave him $300,000 plus 60 in repairs. I said, oil burner, new oil boiler, new roof. I I'm like, whatever. I continue to have all kinds of business. I had my receipts from the third-party providers. I had all kinds of stuff. I had told him years ago that I was saving that stuff so that in case I dropped dead, he was my heir. He would have an increase in the basis of his house taxes because I knew that given his income level, he would really be hit. And so, with capital gains. And so I did that, and I had all the papers, but really it was being saved for him, not me. I never ever suspected that my own son would evict me from the house. So I remember calling him after I got the letter from his wife, and I said, oh, I don't believe this. And no problem with not being evicted. I just simply found the newsletter, and I received 2 more from her. This time they were on computer, they weren't handwritten. But they admitted that she sent them. She admitted that. And it took her from September of 05 to February of 06 to convince him to evict me. He came over to visit, and he left. I didn't know it. He left a summons for an eviction notice for my distributor, which I found 3 weeks later. I don't know, must have fallen through the cracks, literally. And I said, hell no, he's got to do this within 30 days. He's got to file for an eviction court. No reason was given. I mean, nothing about behind payment and brand, nothing like that, because he didn't have it, so he couldn't allege it. Because I had, all this proof of payment, that I had paid him ahead of time on everything. Later on, the judge said, I didn't give him the security deposit. I said, look, I gave him 107 when I first started that trust. I said he only accounted for 90 according to 12 Fargo statements. He put $90,000 in there. I said, what do you call, might not be technically a security deposit, but what do you call $90,000? Swiss cheese? So, anyway, obviously, I ran into court with a life estate complaint. And that was 06, around March 1, 06. And we've been fighting ever since. So, it cost him more in attorney fees than it was worth.
So you know what? Do you talk to your son anymore?
Really, I've tried to negotiate. Yeah, no, I'll never look at it again. I just don't trust him anymore. So long as he's with that woman I know, some people say that he's running it, she's not manipulating, and other people who know her well, oh no, I mean, it's her. It's indescribable what's happened in the communication between us. At any rate, so here's the thing. I have all this evidence. I mean, I had 600 exhibits, and I never had a trial. The judge wrote that I had no evidence. They had no evidence. Now, what's right? I believe this. It should go to a jury. And but what gave me the clue that Margaret Marshall was the justice, Chief Justice of the Massachusetts Judicial Court, must have had a name, because the first decision I had on a motion that I had in that case was by Judge Billings, and he basically it was a good decision. Nicholas Billings in that case. No, it was another case. It was another case. But Billings, it was a decision, it was an immunity case, actually. I was suing the bar when they sued me on the back. And actually said I was right, but he couldn't see following constitutional law from way back because it was old. Oh, dear, what an excuse not to follow constitutional law. And he wrote this in a footnote, because he must have gotten hell after he wrote the first decision in my favor. There were lots of good things, saying I was right, interpreting the statute, and I was right in this and that and the other thing. And I said, what the hell did he put this bar that, it had nothing to do with the case. He did it in, and he put a footnote about that incident, about my informant in my son's case. That was it. And I said, this case had nothing to do
If the disbarment was listed in the paperwork, he was basically, so another judge would see that happened to you, just to retaliate against you and fine the other person.
100% correct. That's exactly why it does. The only plausible reason. And I said, what the hell is this? Okay, then another, I was trying to get discovery. And another judge did something called a motion for request for admission. Well, it's a request for admission. You send it, discovery, not a motion. The request for admission. They have to answer, you know, and then if you want to use, when they object, you have to come in with a motion then, which asks them to find that the objection was reasonable, was sufficient, was not sufficient, and therefore you could use the admission that you requested at trial. And this is a mandatory motion, case after case after case, which says you must make that motion. If you don't, you will not be able to use those requests at time of trial. So I did exactly what was mandatory. I mean, it wasn't, no dispute about that being mandatory. And the guy denied it. Another judge, Moriarty, and he couldn't believe it. I mean, couldn't believe it. So then in the federal court at the same time, I had a malicious prosecution case with the judge that I told you was going to be the overseer of looking of that particular federal committee overlooking the federal judges. His name was Robert C. Collins. And district court magistrate judge. He was a magistrate, but he was reappointed. At any rate, in that case, where the police had lied, anyway, he too put it in a footnote that I was being disbarred. There was no action in federal court to disbar me. What business was it to any court or to the First Circuit of Appeals, the Court of Appeals, had nothing to do with the private chief. Well, because that case, Barb, it predated, I began that case in, I think, 2001, I think it was, in that malpractice case. And it had nothing to do with the disbarment. The disbarment case didn't arise until 2003. Had nothing to do with it at all. It was totally inappropriate footnote to that case. Okay, you're the judicial buzz. That's what I explained. The judicial buzz. There was no question why two judges should mention the disbarment action, which had not yet been resolved, to be in the two cases. And there was just no question that they were inappropriate footnotes. So there was a judicial buzz, and all of this was aimed at letting any appellate judge look at no direction in which they had designed. And so is there a conspiracy? Absolutely. Can you prove it? No.
So the judges fix cases, and that's just the way it is. Well, that's not, it shouldn't be that way. If this video, right, from right...
I can tell you, I'll interrupt you 1 second. You can edit it all out again. On my son's case, I was a victim. I said, what the hell is this? You know, they wanted a partial summary judgment. He gave them that. I moved to Costa Rica in July, as ordered. In August, 2 weeks later, I get a notice from the court. The judge reversed, staying the eviction. I myself again, but I was already down in Costa Rica. And he got rid of the whole thing. He just wanted. But my sense is that his first judgment was so bad, he had no law in it. It was just ridiculous. That he, that he really had to rewrite it if I was going to appeal it. And so that him staying, it was only to give him another chance to rewrite his decision so it made sense legally. And that's what he's in fact trying to do. And he reverted to his own thing. But how many people have been addicted after they've already been addicted? The judge suddenly reverses and no, you can stay here after all. I mean, it was ridiculous. So insane things that happened in that case. So that's why I know that there is a buzz, and the Chief Justice wanted me out, because these guys are taking instructions as to what to do. So when my book got published back in August, I was down here a month, and I said, oh, might be the silver lining behind the cloud. And then I was out of the country when it was published, because it's a whistleblower. My book, Behind the Black Rose, Tales of Justice, is a whistleblower case. I name their names. I disguise the names, innocent for my clients and innocent people, but I do use real names of lawyers who are no good and the judges who are no good. Not all lawyers are bad. Some of them are afraid to say anything because they don't want to lose their license, because they have child support payments, they have alimony payments, they have family support if they're not broken up. I mean, they have lives too. They've got to pay their bills as well. And they're afraid to lose their license if that's the only thing they've done for years. So some of them they might not be all that courageous because there'd be a high price to pay, but they're not necessarily bad lawyers. So you have a mixture, like in every profession, good and bad in every profession. And some of them, of course, make business and make money just following the court position, and they do it to fit. And their licenses are in jeopardy.
All right, so if you're not a team player, you can be disbarred. If you wanted to give just what would fix the system, please just, what you would do to fix the system, the court system, and why don't you give the highlights of your book of why people should buy your book and why they should read it?
Well, what I put in there, each chapter begins with some short explanation, and then I put in anecdotes. Many are from Massachusetts, and many of them from my own practice, but many also are from other stories that I've heard. And when people have told me stories, I've asked them for the court papers to check it. I've checked the docket sheets, I've checked the orders, and I get enough information so I can make a determination whether this is real or they're just, wishful thinking. And so there are stories, there are anecdotes from other people who are not necessarily clients of mine. And some stories are from New Jersey, some are from different states. I try to make it not only Massachusetts, I wanted it to appeal also to people nationwide. Probably not as nationwide as I would like, but I don't know the experiences in all the other states and although they're pretty bad. I mean, I've heard them, and I certainly agree with stuff where people are complaining, but I don't have first-hand knowledge to check that what they have said is true. And that was one of my, because a nitpicker, I am a nitpicker, and I want to make sure that what I say is true, and that I can prove it. Not he said, she said. I want to know that there is paper to back it up, and it's excellent. It's court paper, and it's signed, and it's certified. I want to know the truth. I'm not interested in any judges if they've done the right thing. I want the story to be real. So I'm very careful about using some out-of-state things. But the out-of-state papers, the out-of-state stories that I use, I checked. I did check to make sure there's some substantiation. So I put in each chapter say so-and-so, judge did this to me, but they won't say the judge's name when you want to know the judge's name, and you want to know the lawyer's name, because it doesn't do you any good to not know who to avoid or to be careful about, or to be wary of. Now, not decades ago, remember I'm 75, so when I say decades ago, I mean lots of decades ago, about 5 decades ago when I was in my 20s, and I had a maid, I remember she was from Scotland. She was Irish, but she lived in, I want to say Galway, but in Scotland, in that particular city. I can't remember the name, it's picking out of my mind at the moment. And where lots of the Irish, when they immigrate to Scotland, go to that particular city. Anyway, she used to say it because I was getting divorced at that time. And I said, oh, Margaret, this will be, we used to call her Maggie, actually. Maggie, if we end up getting divorced, we'll be on the front page of the New York Post. And she said, I was a Shelton, you'll only be a 9-day wonder. And she'd always say that I was a Shelton, you'd only be a 9-day wonder. And what she meant is the memory of the public is 9 days at most, and after 9 days, someone else will replace you. And she's right. People who remember, gee, I heard that name, gee, I read about that name, but they don't remember whether the context was good or whether the context was bad. So I want to be very careful when I name an attorney that I thought was bad. I wanted to give the whole story so that they would at least help them to remember the context, because I didn't want to bring them free business. I didn't want to be an advertisement for them. So if I said fraud, I wanted to describe the fraud so that the person would remember, would have better chance of remembering. So that's what the book's for. It teaches, tell them the tricks and the traps for the unwary, so that they know what to expect when they file a particular complaint and they get a motion, they're served with a motion to dismiss. What are they looking for? What is the law that they can avoid? What can they use to avoid it? What can they use to oppose it? That kind of thing. And that's what the book is for. So if they have an ongoing case, it'll be helpful. And if they don't have an ongoing case, but they're about to, or they might, or friends, or they're interested because their best friend is suffering this, I'm really trying to reach beyond the people in the cause. I would like to reach the people also who don't have experience with the courts, haven't experienced the evil that can come out of the court. And believe me, it's evil. Some of the things are truly evil. And I want to educate them. I want them to be aware that we need court reform, that we've got to have court reform, and that we've got to have abolish judicial immunity, which must if we're going to have any justice. Otherwise, the country is not going to be what we were taught growing up that it was.
Okay, if you were in charge of improving the system and the system had to do everything that you said regarding what to do with the courts, what would you order to do right now to fix the courts?
Get rid of immunity right away. And then make sure that the judges follow the law. Hold on 1 second. Yeah. Oh, hi. I'm just going to get off the interview now. Hold on. Just 1 second. Hi. Are we doing, Steve?
Did you want us to add a last footnote, or?
What's the question again?
Okay, the question was, what would you do to improve the court system? You said abolish immunity to judges, but what else would you do to fix the system?
Well, I would definitely do court reform. I would make sure that they follow the law, and that I would like to see a separate discovery court
All right, if judges break the law, should they be arrested? And if found guilty, should they go to jail?
No, you have to probable cause. You have a criminal system, and it should be treated the way any other case is, and you don't go to jail until you're convicted.
But I'm saying if there's probable cause, should a judge be arrested? And if he's convicted, he or she...
Probable cause will vary from court to court.
Okay, but if a judge breaks the law, should they be arrested?
No, what happens in the other is you're not necessarily, well, if they're caught in the act, you can, but someone who breaks the law and is not caught in the act, they're indicted, they're served, this is the whole process to follow.
Okay, say the process is followed, and a judge is found to have broken the law. Should he or she be arrested?
Well, it depends what law is, what the punishment is statutorily.
Okay.
They should be treated the way everyone else is.
Yeah, I agree. Okay, and if they're found guilty in a court of law, and a jury says they're guilty, and if there's jail time for the offense, should a judge go to jail in that case?
Oh, absolutely. They should be treated as everyone else is.
Okay. It's been a pleasure talking to
And
you.
they have to do away with plea bargaining.
Why would you do away with plea?
Innocent people pleading guilty to things they haven't done.
So then pretty much every case would have to be heard. That would clog the system, or they would have to just do a better job of finding the guilty.
They wouldn't bring false charges against people.
Interesting, because they can just put you through. If they had to have cases with merit, then they would have less people arrested and falsely imprisoned.
Right?
All right. It's been a pleasure talking to you, and maybe we can talk again soon.
Thank you. Thank you.
Thank you so much.
Check your editing.
All right. Well, we'll talk soon.
Okay, bye-bye.
Bye.